Events happen that change our lives. Dealing with change is what we do. We discuss with industry professionals objective solutions to work through cherished items and family memories. When we go beyond the gavel, we provide tools and information to deal with these crisis times. Welcome back to Beyond the Gavel. I'm Shane Feely with Auction Solutions. Today we have again with us Monte Schatz in session 404 with estate planning and trust issues. Monte Schatz is with Vandeneck Weaver Attorneys here in Omaha. Thanks, Monte.
Well, thank you. I appreciate you being able to go power through all 4 sessions. So.
Hey, it's okay. You know, sometimes I get a little behind and I have some important information I think that our viewers are going to really enjoy listening to.
Well, I hope it helps. And like I said in our last session, now is a good time to do that review and take a look at, take stock of where you're at in your life, any changes. And
right, you mentioned right at tax time.
Yeah.
Because you're going to know everything that you have, absolutely.
Yep, the numbers are right in front of you, and at that time, a lot of times people are reviewing what their assets are, what their balance sheets are, how their assets are titled, joint title, that type of stuff. And that's a good time to come into your attorney and go to your selected attorney and take a look at that and kind of do a recap. And like I said, if you have an estate plan, maybe time to review it. We recommend our clients as a general rule every 2 to 3 years.
Not a bad idea.
Yeah, if they have more complex matters or some real major life events, maybe come in, once a year.
Sure.
Yeah.
We've kind of covered a lot of senior and parental life-changing events and how you handle that with trusts and things like that. What about, you and I worked on a case where someone's father was overseas and had a death while employed by the U.S. government.
Right. And
how do you handle something like that when there's nobody else but the trustee?
It's, let's start with, when you have that situation, this may sound peculiar, but it's a privilege. If if I'm the attorney or let's say if I was designated as a trustee or I'm representing a trustee, whatever the case may be, and in this case, I remember what you're talking about. Literally, this this father had not seen this child in, what was it, 4 decades, I think, something like that. And there was a little bit of tentativeness because you don't know what the reaction is going to be like. Is it going to be anger, or is it going to be, wow, he remembered me, or and I'll tell you what, it was the most pleasant encounter in this case. What it takes is, there's really not a legal technique to this. It's more of a human emotion. How do you call up somebody and, one, make them think that this isn't some kind of a scam, that this is the real deal. And what I always do is I pick up the phone, just called them, and, introduced myself, told them, in what capacity I was handling this matter. And, and I asked him, I don't know how much you remember about your father. And he said, well, I've only met him a couple times, and I was, I think it was 4 or 5 years old the last time I saw him. And I said, well, he didn't forget you. And, I told him the situation, and he was just like, wow, that's just incredible. And I said, well, what I'll do is follow up, and we sent him a statement that showed what the assets were, because virtually everything was going to go to him, and saw that, and that made it real, and of course confirmed that this wasn't some, some scam or
you do get those calls daily.
Yeah, you do, some fraudulent type of situation, and it was really gratifying, and it was gratifying for him. I think it. Yeah, I can't speak. I never had the opportunity because he was up in Alaska, way up north.
Wow.
Yeah, but it gave I think it brought some closure to him and brought a lot of peace. So that was gratifying to see. Sure. And I think he was an employee of the federal government, and I think he was pretty well situated. His father was, I think, as I recall, 80-some years old, and this guy was at near retirement age. So I think the assets were the secondary thing. I think the bigger thing was just he remembered me. He didn't forget me.
Yeah,
and that was cool. That was really neat.
That is pretty cool.
Yeah.
Well, now what would happen if there was a family in the service armed services and was killed overseas, and you might have a guardianship or a conservatorship, and explain the difference.
Okay, so when you're talking about like a minor child that might be left behind
Correct.
or something of that situation, yeah. So I actually had a situation like that, and as you know, the federal government has a life insurance policy that pays a certain amount for, at the death if they're killed in active duty to the service. And luckily, the specific case I had was there was an insurance policy, and it designated the child as the beneficiary, and the mother of the child, they were not a married couple, and so we don't have the situation of disinheriting a spouse there.
Sure.
So he wanted to take care of his son in this case. And the thing, had there been so let's do a little the guilt laying trip. Had there been a trust drafted in advance, and he would have designated the trust as the beneficiary, that would have been a lot easier. We file a claim through the appropriate channels with the federal government. We prove that the trust is in place. Check comes to the trustee. Check goes into the trust. Trust is managed for the child's benefit. No court interference. Minimal legal time involved, and so forth, and you're off and running, taking care of the child through that trust to the extent that trust can do that. In this case that I had, unfortunately, there wasn't a trust, and again, you can sit there and point fingers, but this guy was in his middle 20s, and you want even in the the line of fire or whatever, you want to believe that they're going to come back, and it's not going to be the one that lost their life.
Forever.
And unfortunately, that wasn't the case here. And so there wasn't a trust. So now you got a scenario of you've got a minor child who at that time was roughly 10 years old, approximately $200,000 in life insurance benefits, plus what other this particular soldier had other things in place. So a trust for about $300,000 in place, and 10 years plus college to take care of that. And then you had this scenario of we didn't know how financially and emotionally responsible the mother was going to be, and I hate to say that about any mother because they
never know.
She was a caretaker and so forth. But anyway, there needed to be something put in place. So now we come to what we talk about in estate planning. What I call is when all else fails. There wasn't a will with clear designations. There wasn't a trust that did that. The life insurance policy designated a minor, who in no way, shape, or form would be equipped to handle,
Sure.
that kind of money and assets for themselves. So now what do? Well, your recourse, fortunately, and it's a cumbersome process, and the courts do the very best they can. But now you've got two dynamics that might be involved here. You might have a guardian of the person. Now this particular child did have a mother, so there is your guardian. But and like I said, it's guardian of the person, making those personal decisions. Where do you live? What school do you go to? Who's going to take you to the doctor? Those daily living conditions. That's the guardian's duty. And then you have the conservator. Now the conservator that's kind of the short word for conservator of the assets. Okay. So that the conservator focuses more on the financial aspects of somebody who's unable to manage for themselves. So we had a conservatorship that went into place, and thank goodness we did, because the mother, though in many cases well-intended, was a little bit generous about how these benefits were going to be used. She was the original conservator, and then there were some financial handlings, and luckily it wasn't a large amount of money that necessitated putting in a bank as the co-conservator on this. And now you got a third party in there, sure. And in addition to the court overseeing that, because the reality is in a conservatorship, typically the court is going to have a once-a-year annual review of the assets. They're going to expect you to submit basically a miniature balance sheet that shows this is what's left in the trust, and accounting that shows this is how the money was spent. Well, the accounting may not always tell the whole story,
Right.
and who's going to audit that person to make sure every transaction is not available. That's where having a third-party intermediary in there, like a bank fiduciary or an attorney that specializes in management of these types of things and administration of these types of things, would be in there, and you'd have a second party in there in addition to the court overseeing this between those two periods of accounting. And that's what we had, because frankly, we had discovered that, when little Johnny was being taken out for a meal, well, when you see $80 at McDonald's, it's like Johnny in whose arm he was at this
Yeah.
thing. Well, there was friends and other people, and they were picking up the whole tab, and it was like, no, this isn't going to
Yeah.
work.
That's a tough
And
thing
so,
too.
and most importantly, we wanted to make sure, that conservatorship is for that, what we call the ward, that protected person. And in this case, particularly you got a vulnerable minor child. It can also be the case in somebody that has mental disabilities, and there may not have been a trust set up. Maybe maybe a case where it's determined that the person is at risk to themselves and is financially unable to manage their matters for themselves for varying reasons. Might be alcoholism, might be drug abuse. Sometimes these things, particularly when it's a minor child, that conservatorship stays in place until they turn the age of 19 in Nebraska. Sure. In Iowa, it's 18 or a year lower on that. But sometimes, sometimes the conservatorship can go away. If there's a case of alcoholism and the person's maybe turned their life around and has been able to do that, sure, then they can petition the court to remove it. But again, there is that third party there that can make that tough decision.
What about a nursing home situation or a home care situation?
Yeah. This is getting to be the most pervasive and common problem in today's society. Again, we hear this phrase all the time, the largest intergenerational transfer of wealth. And unfortunately, there's some very bad people out there who are very aware of this statistic too. And where we see people who have worked their whole lives and deserve to live well off of that, and if they have anything left at the end of the day, at the end of their lives, to pass that on to the next generation, some of these people see opportunity to enrich themselves from it. Where I've seen it happen frequently is particularly where there's a older adult who lives at home, might not have children around, may even have children around. I had a situation where a very concerned son was overseeing matters, and he was checking in and all that, but all of a sudden, one day, and this is the classic, as you can go through all the complexities all you want, but what you typically see is the elderly person who may be vulnerable, might have diminishing capacity, maybe early dementia, maybe something not that severe, right, but are just extremely forgetful and extremely trusting. And this one person came in and charged $4,000 to trim her bushes, and he saw the invoice. And that, like I said, the kitchen table is usually where it starts. That's where the bills are, and they see this and they go, oh my gosh. And so they came in, and luckily she had the client had the level of capacity where we could still, start a trust. But if we wouldn't have, we would have had to go to the court and ask for a guardianship perhaps and a conservatorship.
Wow.
But now we have the tools in place that doesn't happen anymore. Sure. Because it's real simple. You work with the protected person, whether as a beneficiary of a trust or as somebody that the court's overseeing in a conservatorship, that you just simply tell the person, I don't handle my own money, I can't address the situation with you, and then they go away.
Yeah, it's amazing how quick they go.
Oh yeah.
We had a guy he'd stolen a pickup truck that was selling frozen meat out of the back for a company, and he hit my mom's street, and it was like, who are you?
Yeah.
Where did you come from?
And sadly, unfortunately, the easy scenarios are the ones I described, where there was just a unscrupulous third-party vendor. Where it really gets difficult, though, is if it's a family member that's abusing the finances, and it's kind of like the estate planning equivalent of what you see on the criminal side. the victim knows the murderer typically 80% of the time, and there's a significantly high percentage of abuse, mental, unfortunately sometimes physical and financial abuse of our elderly, from their own relatives, and sadly even their own children sometimes. And that gets a little bit tough because we do have mechanisms in place through our county attorney's offices to deal with that, but it's a tough situation sometimes because it's really tough to walk into a family dynamic situation. In fairness to the Douglas County attorney, they're overwhelmed with a lot of cases handling a lot of different things, and it's pretty tough for them sometimes to walk into this family situation. So what does that leave as your primary recourse? You got to do it civilly, and that's where you start talking to people like myself and so forth that hopefully can put some tools in place, guardianship, conservatorship. Hopefully there may have been a trust in place, and then we just get the right person there to assume the trusteeship and take over the finances and start protecting them and putting them in a better place.
And we had handled an estate that a large amount was missing, and it never did. There was nothing that the attorney at that time would do because it was family, and family normally doesn't sue family. They have a tendency to let it go. Yeah. Which is,
Yeah, yeah, and the thing that happens so often, there is this fine line sometimes, especially if you're a party that's coming in after the fact and don't know the dynamics ahead of time.
I'll bet.
A lot of times kids and others can mentally justify it. Well, I was the primary caretaker, so I really wasn't getting paid to do this, so I felt it was only right that I would be able to pay my mortgage from mom's finances as kind of a way of compensating myself. Well, again, that may not be wrong, but it goes back to that premise we've talked about so many times. If you really feel that way, then, and you're confident that wouldn't be that big of a source of controversy in the family, then why didn't you ask for it in advance and disclose it to the other members of the family where it was kosher and all approved by everybody, rather than after the fact where you've raised suspicion that you're never ever going to be able to reverse. You've lost the trust of the whole family at that point.
I agree on that.
Yeah.
Let's just real quick talk about secret beneficiaries.
Secret beneficiaries.
Yeah. Let's say
tell me what that means.
You've been married for 40 years and you have 3 kids, and you didn't know your husband's past, or he didn't know yours, and all of a sudden you have an heir from somewhere.
Ah, yes, okay. Yes, the unknown and the hidden child or other relative, yeah. So the thing that you always get into there is, particularly if they're, and I'm going to use the child example. So you have, traditional nuclear family, husband and wife, and they may have in a past distant relationship had a child out of wedlock that they never acknowledged, or, tucked away and we didn't know about.
Oh, and then there's those secrecy laws that were back in the day, so nobody really talked about any of that.
Oh yeah, right, yeah. It definitely was much more, it was much more of historically a shameful thing, and you just didn't share that with people unless you absolutely had to. That's right. And so where that can get sticky is where you have the situation where there's 3 children that are of the marriage of this bond between a husband and wife, and there's this other child that's out there who maybe have rights as a child. Perhaps they weren't legally adopted, perhaps the parental rights were never terminated and so forth from that, and they can, quote, sneak in, hence the secret beneficiary, right, and stake a claim to that.
Well, it's not even a sneak in. If their mom or their dad told them the name of their parent and they've kind of been keeping an eye on them, now with the internet, everything's out there.
Right, absolutely.
So it's not even sneaky anymore, it's kind of claiming their right.
Right, so they can go in there and claim their right. So a couple of ways to deal with that. One, if there's some doubt as to whether that was the actual child, with current DNA testing and so forth, there may be a way to, narrow down the probability of, is this really a child or is this a scam? There may have been a relationship with that other person, and there may have been a child born of that, but that person may not have been the father or may not have been. So now you go into more sophisticated DNA testing. Then the other thing is, again, I go back to my rule of transparency, which is if something like that happened in your life and you have any doubt, you can address that.
Absolutely.
Now, if you feel no obligation legally, morally, however you want to couch it, that you want to leave any share of your estate to that particular child, identify that child and you know, disinherit them. I mean, and you know, you can do that with just blunt language in the trust, or you can put in, you know, additional terms that explain it, that, you know, because I know you have been taken care of by other people, and we never, you know, developed that formal parent-child relationship. I acknowledge that you're, you know, you're out there, but I'm not leaving any part of my estate to, you know, and obviously the language is going to be a little bit more tasteful than that, but that's kind of the gist of it. So
The reason I ask is I have had that happen on 2 accounts where we were working away and setting up the auction, and they mentioned that there's somebody else popped up and they were doing a DNA test to make sure that they were actual family, because I think sometimes shirt-tail cousins, or even people who know shirt-tail cousins, sometimes want to be a part of getting something.
Yeah, and I'll tell you again, it's a part of it. If there's any doubt, especially if you're a trustee or a personal representative, if there's any doubt, it's really incumbent on that trustee, that fiduciary, to do some due diligence. You know, in my days when I was in the trust industry, we ran into a situation like this, and this person came up, and yes, nobody denied that there wasn't some relationships between the decedent and this person's biological mother, but you know, there was some innuendo and some thought that maybe perhaps this person was the father. Now, if we didn't do our due diligence, we may have written out a check to somebody that had no right to that.
Sure.
And sure enough, we said, you know, we will stipulate there may be a distribution, but it's subject to, you know, DNA testing. And sure enough, they did the paternity/DNA testing, and our guy wasn't it. So I mean, if there's any doubt about that, and if the family's aware that there's a questionable situation of right to an inheritance, then I think it's really incumbent on the fiduciary to follow through and make sure that's verified or not verified, as the case may be.
So your family member passes, and there's a life insurance policy. Is that something that's taxable, or is that something that you can distribute without? Can I get into some of your tax questions? I know you're really good at them. I just have a couple minutes here.
Right. No, and there are some types of policies, whole life policies, that do have taxable elements to them and so forth. And the thing is that what you want to do at that point, but typically a straight life insurance policy, you know,
like
a term life, something of that nature, no income tax on the actual benefits. Now, people will go, but I received this 1099 on the insurance policy. Sometimes if there isn't an immediate distribution made after death, the insurance company by law has to pay, to the extent that the distribution is delayed, needs to pay interest on that.
Oh, gotcha.
So what you'll see is, you know, I'm just using a fictitious number, a $200,000 payout, but you'll see a $200,020.27 check come out. That's the interest on that. But as you can tell, typically that is not taxed at all. So again, that's a great benefit and a powerful tool in estate planning. And you know, we alluded to that in previous sessions about how that can resolve a lot of business succession problems, cash flow issues, potential source of funds for federal estate taxes, and if properly structured, insurance benefits, life insurance benefits, if they're structured not to go straight into the estate, do not get taxed for federal estate tax purposes. If you put them into a type of trust or something where it doesn't pour into the estate, then you can avoid the taxation of the benefits. What could be more frustrating? You take out $1 million policy thinking it's going to pay for the $800,000 in estate taxes, and then you find out, I had it go straight into the estate, or didn't have it go into a trust outside of my estate, And oh, by the way, 40% of that's, you've taken $1 million and 40%'s taken off the top. Now you got $600,000 left
Yeah.
to meet an $800,000 obligation.
Right, and now I still
Ooh.
have to borrow $200,000.
Yeah,
Everybody
that's-
sign here.
Yeah, that's not where you want to be,
No,
and,
not
and
at
clearly
all.
that defeats the whole design of the life insurance and its purposes to keep liquidity.
So going back, we'd rather do a direct distribution to families rather than start a probate. I mean, probates are important, but if the
Yeah.
estate is small enough and everybody's on the same page, to just do a direct distribution of assets and things like that, or do you still want to file probate?
There may be reasons. Let's start. I'm going to answer that question with, and I think we've discussed this in previous sessions we've had before, where, the popular financial and legal press to a degree has really overplayed how awful probate is. And they'll hear the stories, your estate will be tied up for years and all that. Well, a lot of times that's not a function of the probate process. That's a function of what kind of probate is it. If you have a harmonious family and they get along and and they didn't have a trust in place, I still like the trust better because I think it can be a more expeditious way. But the bottom line is this: is that what it does is the estate it's not a bad thing, and the only time it really gets tied up is when it gets to be a contentious matter,
Sure.
That type of thing. So anyway, those are the types of things, but the trust is probably the preferred vehicle. Where
I
you
can
do
tell that it is, and I know that you work with those a lot, and
Yeah.
I've worked with you through those many times.
Yeah.
Thank you for going with us today behind the gavel. Again, thank you, Monte Schatz, session
you.
404 with Vandenack Weaver here in Omaha, Nebraska. If you have any questions, his number will be across the bottom of the screen. If you have any questions for us or anything you'd like us to address, please go to www.beyondthegavel.com. Thank you.